Next, the chair recognizes the gentlelady from Hawaii, Ms. Hanabusa.
Thank you very much, Mr. Chair. Secretary Ryan, have you had the opportunity to read the testimony of the governor of CNMI?
Are you talking about today's testimony?
Right.
No, I have not read it in full. I have only been able to listen to his oral testimony today, but I will do that when I get back to my office.
Well, let's just go to what you heard in terms of his testimony. He's raised in opposition to this particular measure about 11 different concerns. Do you know if the rules that you are proposing to implement, I think by mid-September, it was your estimate, would be addressing his concerns that, well, you heard him testify to?
I understood the governor to be talking about the people that aren't currently covered in the transition rule and stating in opposition to that. And then I heard my colleague from GAO suggest that the number that he had raised might be somewhat inflated. My understanding with the investor rule is that we will, be ready for it in advance of the November 28th deadline, and that we are fully engaged in having it be operationalized. I don't think it would cover the people covered in Mr. Sablan's bill, as I understand it. They're a different category of people. So I think what we have committed to is looking at parole authority for certain groups that were not covered in the CNRA, and also working with the committee on the legislation itself as it moves forward.
Okay, that's an important point, because I wanted to be clear in my mind that you are not talking about the same group that Mr. Sablan is speaking to. He's talking about 4,000 very specific individuals. So the rule that you've testified to that will take effect in mid-September will not cover those 4,000. So Ms. Doctor's, for example, her parents would fall through the cracks.
The rule that will come out relating to the worker rule will permit petitioners to file for persons there. But as I understand it, the categories of people that Mr. Sablan's bill is designed to address would not necessarily be covered by that. There may be some crossover in some cases. I don't want to mislead the committee, but my understanding is he's trying to help for specific groups of people that may be 3,000 to 4,000 persons in size that would not automatically be covered by our rule that will come out before November 28th, hopefully.
So assuming that Ms. Doctor's parents fall in the category that is not covered, what then will happen to them come November?
Well, as I understand from Ms. Doctor, and I don't have access to her family's records, but as I understand, her parents right now don't have the ability post-November 28th to remain lawfully in CNMI absent either parole or some other legislative action. But again, I don't have specific access, but that's how I understand the situation to be in Ms. Doctor's case.
So in that situation, the only way that we would be able to ensure that Ms. Doctor will continue her education in the United States and return to CNMI as a psychiatrist would be if her parents are somehow covered under 1466.
As I understand it, there's, I think, 3 options. If the bill passes, that presumably her parents would be covered, there would be parole, the potential for parole, and the third option would be if her parents' employers petitioned for her and got her employment status based on their working relationship with her. So I think there's 3 avenues that I think are available depending on the actual circumstances.
And Ms. Ryan, given the fact that, and this is no insult, but it's taken so long, and we're talking about November of this year, is it that the bill is probably the most fail-safe way to address this specific group of 4,000?
On the investor rule, I would say that while it has taken a long time, part of the reason that is the case was that we were enjoined from implementing it by federal litigation. So that has been a part of the delays that I should say. I think given the timing here, we are very aware that we need to get our rule out so that employers have opportunities to make those filings. I'm not sure about the calendar of the Congress and whether which one will happen first. I suspect our rule will get out before there would be an opportunity.
But we already know that your
legislation.
rule will not address this group of people.
It would address it potentially, as I said, some of them,
Right.
because if they had an employer who could file a petition on their behalf. But as I understand it from the description of the ranking member, it would not cover all of them.
Thank you very much. Thank you, Mr. Chair.